On my channel, we spend a lot of time talking about trust planning, whether it's an irrevocable trust or a revocable living trust. We talk about the various advantages, disadvantages, when and why you would want to use a particular type of trust, and the various mechanics behind it. But one of the things we're going to talk about today is a certain type of asset class that will never go into your trust. So let's get into it. All right, so whether it's a revocable living trust or an irrevocable trust, there's certain types of assets or an asset class that will never go into a trust regardless of what kind of trust it is. So as a quick reminder, a revocable trust is typically used to avoid probate. So rather than having assets in your individual name or jointly held with your spouse or someone else, you'll put those assets in the name of a revocable living trust. That simply means that when you die, those assets are already in trust, not your individual name. So therefore, they're going to avoid probate. So it's really a probate avoidance vehicle. There's not a lot more to it, although sometimes you can bake in some tax planning. Big thing is probate avoidance. Okay, with an irrevocable trust, we're mostly focused on really a few different things, but we're focused on estate tax planning. So to the extent that you would be subject to estate tax, there's estate tax minimization strategies we can implement with an irrevocable trust. Asset protection is another benefit of an irrevocable trust. So protecting assets from personal creditor claims or divorcing spouse, those types of things. And then lastly, maybe it's family governance. So if generation one wants to put certain parameters on how these assets are to be used or how they're to be governed, then that's another aspect of it. Okay, so regardless of its probate avoidance or estate tax planning, asset protection, family governance, regardless what you're really looking at, there's certain types of assets that will never go into a revocable or an irrevocable trust. And the one that never goes into it is in a retirement account. So whether it's an IRA, an IRA, as some people call it, or an IRA, and then 401k or its equivalent 403b, a retirement account of any kind is never going to go inside a trust. And the reason for that is because it's an individual retirement account, as the IRA says. So the individual itself, the person, has to own that account. The only way to move those funds or those assets from the IRA, the 401k, the 403b, whatever it is, the only way to move those assets over to a trust would be in liquidation of those accounts, making a distribution to the trust. And when that happens, there's going to be a taxable event. So you don't want to do that. And And then I also want to focus on the asset protection aspect of that. So you don't want to do that because you don't want to trigger an income tax issue when you don't have to. So avoid that. The other thing is those retirement accounts can avoid probate without having to be put in trust if you leverage beneficiary designation. So, you go into your online portal with Fidelity, Vanguard, whoever it may be, and you indicate on there that you want the beneficiary to be your surviving spouse or your children, or maybe it is a trust when those distributions start being made. And that's something for another time, another video. But either way, a trust could be a beneficiary of a retirement account, if that made sense for you to do. So it can avoid probate. So that negates the need to even put it in a revocable living trust. Now, the other thing is, because you can't put it in an irrevocable trust, it will be part of your taxable estate to the extent that you have a taxable estate. So in 2025, up to $13.99 million in assets for each individual is free of any estate tax. Anything over that will be subject to estate tax. So if you fall underneath that, that's great. You're not going to be subject to estate tax as it is. If you are, then you have to focus on moving other assets out of your name. Your retirement accounts, unfortunately, are going to be in your name. All right. The other interesting aspect of this is asset protection, right? So Each state has different laws around asset protection, protecting assets from personal creditor claims, divorcing spouses, etc. So this is just kind of a general caveat. But in some states, retirement accounts are protected from creditor claims. So that's something to be cognizant of and aware of when you're thinking about, do you have an asset protection plan? But so there are some benefits, even though you can't put them into trust. There are some benefits to those accounts that already exist that would negate the need to ever put them in trust. But the big thing here is retirement accounts will never go into a revocable trust. It will never go into an irrevocable trust. But that's okay because you can still avoid probate. You can still potentially protect these assets from creditor claims.